Hello viewers, welcome back. This is Subathra Mylsamy, partner at AK Mylsamy and Associates. So today's topic is going to be on the groundbreaking aspect of where the Bar Council of India has regulated its rules and regulations, welcoming foreign lawyers and the foreign law firms in our country. The Bar Council of India has made a great decision to allow the foreign attorneys and the legal firms to practice law in India on a very reciprocatory basis for non-litigious matters only, along with prescribing the eligibility criteria for practicing law in the country. The new rules also list out the matters which may be handled by the foreign lawyers and the foreign law firms. This has come into effect from March 13, 2023. The Bar Council of India notified the Bar Council of India rules for registration and the regulations for foreign lawyers and foreign law firms in India. I would like to talk about the object behind the rules. The demand for an open, responsive and receptive legal professional dispensation mechanism in India from clients, public who operate in international and cross-border business is becoming more and more every day. Growth in international legal work sphere and globalization of legal practice and internationalization of the law is increasingly becoming relevant to the growth of the legal profession in India and also the practices in India. The earlier position, as we all know, that the Bar Council initially didn't oppose the entry of foreign lawyers and foreign law firms in India. However, it authorized the legal fraternity of the country in the years 2007 to 2014 with the joint consultation of conferences of the Bar Council of India as well as the state bar councils with the appropriate government ministries to explore the potential and the prospects of opening the law practice in India for the foreign lawyers in the field of practice of foreign law and diverse international legal issues only in non-litigious matters on the principle of reciprocity. And the outcome today is that the new adoption of the rules and regulations by the Bar Council of India. Now, what are the outcome of these rules? Now, opening up of the law practice in India for foreign lawyers in the field of practice of foreign law, diverse international legal issues, in non-litigious matters and also in international arbitration cases would go a long way in helping the legal profession and the domain to grow in India to benefit the lawyers in India as well. It is to be noted that the standards of Indian lawyers in proficiency in law is comparable with the international standards, and the legal fraternity in India is not likely to suffer any kind of disadvantage in case the law practice in India if it is opened up to the foreign lawyers in a restricted manner and also in a very well controlled and regulated manner on the principle of reciprocity, as it would be mutually beneficial for the lawyers from India and abroad. And these rules are an attempt by the Bar Council of India in this direction. These rules will help to address the concerns expressed about the flow of foreign direct investment in the country and making India a hub of international commercial arbitration. These rules also will enable the foreign lawyers and the foreign law firms to practice foreign law and diverse international law and international arbitration matters in India in a very well defined, regulated and controlled manner. The procedure for the registration in the Bar Council of India. Now, a foreign lawyer or a foreign law firm can apply for the registration under the rule in Form A, along with a registration fee and a guarantee amount, either in person or sent through a registered post. The registration, once done, shall be valid for a period of 5 years only and would be required to renew it by filing an application for renewal within 6 months before the expiry date. It is to be noted that the Bar Council of India may also refuse to register any foreign lawyer or a law firm if, in their opinion, the number of foreign lawyers or the law firms of any particular foreign country which is registered in India is likely to become disproportionate to the number of Indian lawyers for the Indian law firms which is registered or allowed to practice law in the corresponding foreign country. Once the application has been submitted, the Bar Council of India or the committee shall examine the application, hold an inquiry, as well as check the genuineness of the contents and the documents which has been attached with the application. The Bar Council also will examine the relevant laws, rules and the practice in order to ascertain the truth about the reciprocity with the concerned foreign country, and after such examinations and inquiry made in the application, if it is found to be fit for the registration, then the Bar Council shall grant a certificate of registration. So what can a foreign lawyer or a law firm be allowed to do in India? The areas of practice of the law by foreign lawyers or the law firm is laid down by the Bar Council of India. Now, the foreign lawyers are allowed to practice on transactional work, corporate work such as joint ventures, mergers and acquisitions, intellectual property rights, drafting of contracts and other related matters on a reciprocal basis. Doing work, transacting business, giving advice and opinion concerning the laws of the country of primary qualification. Here the country of primary qualification means that where the lawyer has been enrolled as an advocate to practice. They can provide legal expertise or advice and appear as their lawyer for a person. It can be a firm, a company, a corporation, a trust, a society, etc., where one has the address of the principal office or their headquarters is in a foreign country in which there is an international arbitration case and which is conducted in India, and in such arbitration cases the foreign laws may or may not be also involved. They can also appear and also give the legal expertise or advice as mentioned above for before the various bodies other than the courts, tribunals, boards and statutory authorities who are not legally entitled to take any evidence on oath, in which the knowledge of the foreign law of the country of the primary qualification is very essential. They can provide also the legal advice or the expertise concerning the laws of the country of the primary qualification and on diverse international legal issues, provided that such legal expertise or their advice shall not include any kind of representations or preparations of the documents regarding the procedures before the Indian courts as well as the tribunals or any other authority which is competent to record evidence on oath or the preparation of documents or petitions, etc. And the most important point to be noted is, if an advocate of India is being enrolled with any state bar council in India and is a partner or is an associate in any of the foreign law firms which is registered in India under these rules and regulations, they can still only take up the non-litigious matters and can advise only on the issues which is relating to the countries other than the Indian laws. So even these lawyers have no advantage or right of being as an advocate who's been enrolled in India. Now, what are the registered foreign lawyers or the foreign law firms who are registered here entitled to do? Now, one is to open the law office or offices in India for carrying out their practice in India, to engage and procure legal expertise or advice of one or more Indian advocates who are registered as foreign lawyers, to enter into partnership with one or more foreign lawyers or foreign law firms. Limitations for the foreign lawyers or the foreign law firms which are registered in India are that even once the registration and renewal is done, it shall not in any way entitle them to have a free and unregulated entry or stay in India, for which it remains governed by the Indian law and the lawful orders or the instructions which is being issued by the government of India, the state governments and other statutory bodies or any other competent authority in India from time to time. As mentioned before, a foreign lawyer who is registered under the rules shall be entitled to practice law in India in non-litigious matters only, subject to such exceptions, conditions and limitations which are laid down in the rules. Now, the foreign lawyers or the foreign law firm shall not also be permitted to appear before any courts, tribunals or other statutory or regulatory authorities, and they shall not be involved or permitted to do any work which is pertaining to conveyancing of property, title, investigation or any other similar work. I would like to conclude by saying that many countries have already allowed foreign lawyers to practice foreign law and diverse international legal issues and arbitration matters in their countries in restricted fields with specific and prescribed conditions. So the entry of the foreign lawyers will create much more opportunities for the Indian law firms to be exposed to global best practices and encourage also healthy competition. This will also result in modernization of the business services and investment in high-end technology for the Indian law firms. I hope this video would have been informative for all of you. Thank you so much for watching us, and until then, take care. See you next time.